On, ladies and gentlemen, fellow patriots, my name is Abner Collins-Mango, advocate of the High Court of Kenya and partner at Bikagunyi and Company Advocates. Welcome to Court Helicopter. And on this week's episode of The Explainer, we shall be discussing the Computer Misuse and Cybercrimes Act. Now, the initial bill was drafted around the year 2016-2017 by the former regime. So the act was aimed to fight cybercrime, protect digital transaction, and to safeguard national cybersecurity. Now, while being debated in Parliament, three major points arose as points of argument. It was seen that this could be an act that was aimed to curtail the freedom of expression. Secondly, there was an issue of there being instances of government overreach. And finally, it seemed like the act was to create oversight of digital platforms. Remember, the digital space is a free space where people are allowed to express themselves, market themselves, and give views and opinions, whether pro or anti-government. Now, the act, if we looked at the definition of the act, it is an act that is specifically enacted to provide offences related to systems and to enable timely and effective detention, provision, response, investigation, and prevention of cybercrime. Now, the law speaks on a number of aspects. Number one, it speaks into aspects of hacking. We all know what hacking is about, where somebody unlawfully gets into account and takes control over it. Number two is identity theft, whereby somebody opens a pseudo account and continues operating that account in the guise that that person is you. Number three, the issue of cyber harassment or cyberbullying. This is what maybe Kenyans nowadays refer to kusalimia, where somebody is harassed, is bullied, or maybe shamed, or whatever. Number four, it was also meant to prohibit false information. Now, if you remember even the story revolving around the late Albert Ojwang, the real story was that there was a publication that a fake headline was created in the guise of one of the prominent newspapers that had a fake headline regarding the Deputy Inspector General of Police. Number five is the issue of child pornography. We all know what that entails. Number six, cyber terrorism. Now, Kenya has been a victim of terrorism, and we all know or can relate to what terror is and what acts of terror can entail. Finally, the issue of computer fraud. Now, this is where people are swindled online. We have seen this severally and through several measures. So we look at issues like the one I mentioned, like cyber harassment, that is provided for under Section 27. The issue of false information, if you look at Section 23, it talks about that. If we want to look at the issue of child pornography, it is under Section 22. If we want to look at the issue of cyber terrorism, that is Section 33, and computer fraud, that is Section 26. Now, of very importance and what this act creates, it creates what we call the NC4. That is the National Computer and Cybercrimes Committee. This is under Section 4 of the Act. Now, this is a committee created to bring into force or to help the government come up with the laws, regulations, and to generally monitor issues to do with computer and cybercrime. Now, you want to know who constitutes of this NC4. The NC4 has the PS, Interior. It has the PS, ICT. It has the Honourable Attorney General. It has the Chief of Defence Forces. It has the Inspector General. It has the Director General of the National Intelligence Service. It has the Director of the Communication Authority of Kenya. It has the Director of Public Prosecution. It has the Governor of the Central Bank of Kenya, and it also has a director of the said committee who does not even have a right to vote. He basically just takes the minutes. Now, this MC4, as I'm referring to, whatever they do, wherever they sit, they do report to the Cabinet Secretary of Interior. So all this, as I firstly mentioned, that this act is specifically bringing into criminal offences of all cyber crimes or everything to do with computer misuse. Now, recently, on 15th October this year, when we lost the Right Honourable Prime Minister Raila Odinga, several laws were amended, and the President of the Republic of Kenya signed these amendments into law. These amendments, part of those acts that were amended, included the Computer Misuse and Cybercrime Act. And this brought a lot of talk, a lot of uproar among Kenyans, because Kenyans wanted to know what is this that was necessarily amended. Now, to highlight two sections that were amended is Section 6 and Section 27. Now, Section 27, as I had initially mentioned, was on cyber harassment. And on cyber harassment, there is a word called grossly offensive. So it says if you publish or if you make cause to be published a message that is deemed to be of grossly offensive nature and affects a person, that's what the section talks about. So the amendment includes or introduced or causes the person to commit suicide. So it was not only affecting the person, but it also causes the person to commit suicide. Then the fine that is imposed under that section is a fine not exceeding 20 million or a jail term not exceeding 10 years. So that if you're to be found guilty of having published a grossly offensive message, then what you're likely to face is a jail term not exceeding 20 years, or, sorry, a fine not exceeding 20 million, or a jail term not exceeding 10 years. Now, we all know very few of us can get 20 million. So it means that more often than not, you would be facing a jail term of 10 years. But various institutions, various Kenyans moved to court to challenge these amendments. The matter is currently before court, and it is waiting hearing and determination, albeit there being conservatory orders, which means that enactment of this amendment have been stayed or have been conserved pending hearing and determination of those petitions, so that the court can be able to hear and determine what has been challenged or what has been petitioned. But we will find that those who have challenged court wants the court to interpret what is this that is deemed to be grossly offensive. Because the word as is overly broad or vague, or you can say vague, or is subjective in its language, whereby it depends on whose eyes does this grossly offensive, how broad. There's no meter to measure what grossly offensive could be. And now that it raises serious criminal sanctions, then there's need for the law to be able to define, or for there to be clarity as to what should be deemed as grossly offensive. Secondly, affects a person. So then we are asking ourselves, what does it mean to affect the person? Is it psychological? Is it emotional? Is it reputational, or otherwise? So those are some of the things that are currently before court for determination. The second section that has been challenged is section 6 that talks about now the issue of immoral. Now, I talked of the NC4. So it criminalizes creation, dissemination of one, pornographic. I think that one is clear. But now there's the issue of immoral or sexually explicit content. So for those who have challenged that section, are asking this court, what is deemed as immoral? What is the threshold? Is it the biblical threshold? Is it the social threshold? Is it generally the religious threshold? So that all that the people at before court are challenging or want to seek interpretation on is that there should be precise clarity as to how these amendments are to be looked into. So generally, Kenyans, ladies and gentlemen, this is a conversation that we are having. The act was brought with good intention because we cannot deny that we have had instances of cybercrimes being committed. We have had instances where we have lost money. We have had instances where even our digital transactions, our banks have been hacked. We have lost millions. We have lost shillings. We have also had instances where children are being exposed to pornographic material. So all that we agree is good. They need to be checked. And the NC4 needs to work under its mandate and make sure that Kenyans are protected under this act. But at the same time, we are also saying that this act should not be used to weaponize or to be subjective to Kenyans who, as I remember when we began this discussion, at the point of implementation of this act, did not want their freedom of expression to be curtailed. They wanted to express themselves freely. They wanted to be able to use their space or their digital space for marketing, making money. We have our online creatives who use their social media platforms to make their money and earn their living. So, ladies and gentlemen, that is the explainer today for the Computer Misuse and Cybercrimes Act. Thank you.